Today we're going to look at the case of New Zealand Shipping and AM Satterthwaite. This was a New Zealand case which had been heard by the Court of Appeal in New Zealand and went on appeal to the Privy Council. It's a decision from 1974 which is very important in terms of understanding certain aspects of consideration. The case also tells us about offers, in particular unilateral offers. Let's start by looking at the facts of the case. So what happened here? Well, this is essentially a case about the sale of a machine, and the machine was manufactured by a company called Ajax, located in Manchester in England, and the machine was sold to another company called Satterthwaite, located in New Zealand. Now obviously that machine had to be transported from England to New Zealand, and this is where the shipping company comes in. So the drilling machine was transported from Liverpool in England to New Zealand, to Wellington in New Zealand, on a ship called the Eurymedon, which is also why we sometimes refer to this case as the Eurymedon case. And the owners of the Eurymedon, that means the shipping company, was called Federal Steam Navigation Company Limited. So there was a contract between Satterthwaite and Federal for the transport of this machine from Liverpool in England to New Zealand. Now, as part of its duties in terms of getting the machine to New Zealand, Federal employed another company, and this company was called New Zealand Shipping Company. Essentially, New Zealand Shipping Company were the stevedores who unloaded the ship once it arrived in New Zealand. Now, sort of small point on the side is that Federal Steam Navigation was a subsidiary of New Zealand Shipping Company, but that shouldn't concern us for the purposes of the legal principles we extract from this case. So what happened once the ship, the Eurymedon, arrived in Wellington is that New Zealand Shipping, who were supposed to unload the ship, damaged the drilling machine while they were unloading the ship. At the time that the drilling machine was damaged, it belonged to AM Satterthwaite. That's because the bill of lading had been transferred from the manufacturer's Ajax machine tool after they dropped off the machine at Liverpool, and the bill of lading was now in the possession of AM Satterthwaite. Again, this is a smaller point that we don't need to concern ourselves with too much. It's really in the area of shipping law that we need to know about bills of ladings and how all that works. So we're really looking at it from a contract law point of view, both in terms of consideration as well as in terms of the unilateral contract and unilateral offers. So let's try and look at a graphic here to try and illustrate what we know so far. So far we basically have two contracts. We have a contract between the owners of the machine, AM Satterthwaite, and the shipping company, Federal Steam Navigation. And that contract is essentially a contract whereby Federal Steam Navigation promises to bring the machine all the way from Liverpool to Wellington in New Zealand, and in return they get paid for that. And there's a separate contract, and that's a contract between Federal Steam Navigation and New Zealand Shipping. And that contract is one whereby New Zealand Shipping promises to unload the ship once it arrives in New Zealand, and then they get paid for that by Federal Steam Navigation. So two contracts, that is not in dispute. Those are the facts so far. So what kind of legal issues arose once the machine was damaged upon unloading in New Zealand? Well, the legal issues really relate to an exclusion clause, because the contract, the first contract, the main contract, the one between Satterthwaite and Federal Steam Navigation, contained a clause whereby Federal Steam Navigation excluded all liability for loss or damage unless a suit was brought within 1 year after delivery of the drilling machine. The exclusion clause also limited the liability to £100 and things like that, but we don't need to focus on that right now, because this part of the exclusion clause, the 1 year limitation, is what's at issue in this case. That is because when the case was brought, it was brought after 1 year. So in terms of bringing the case, Satterthwaite bringing a case against Federal Steam Navigation, that would not have been possible on the basis of this exclusion clause. However, the same contract, that means contract 1 between Satterthwaite and Federal Steam Navigation, also contained a clause whereby the exclusion clause, that means the limitation to be sued only within 1 year and not thereafter, that clause purported to extend to any servants, agents, or contractors of Federal Steam Navigation. So in essence, what Federal Steam Navigation did in their contract with Satterthwaite was to say that we exclude this sort of liability and you can only sue us within 1 year. And by the way, you can't sue any of our contractors, servants, and so on either. So we extend this benefit under the contract to others. Now, AM Satterthwaite clearly couldn't sue Federal Steam Navigation because a year had passed. So what they did instead is they sued New Zealand Shipping, the stevedore company, who acted as a contractor for Federal Steam Navigation, because remember, Federal Steam Navigation had a separate contract, Contract 2, whereby they paid New Zealand Shipping to unload the ship once it arrived in Wellington in New Zealand. So the question really, the legal issue really comes down to one point. Is it possible that the exclusion clause, which had been agreed between AM Satterthwaite and Federal Steam Navigation, extends to New Zealand Shipping, or is New Zealand Shipping not privy to that, basically just a third party, and can New Zealand Shipping therefore not rely on this 1 year time limit? That in essence is what this case was about. So let's try and illustrate this. So we know for a fact that there are definitely two contracts. The one, again, between Satterthwaite and Federal Steam, and then a second contract between Federal Steam and New Zealand Shipping. So the question really is now whether there's a third contract between Satterthwaite and New Zealand Shipping. And the only way this could have possibly been the case is if somehow the first contract, the one between Satterthwaite and Federal Steam, incorporates some new third contract that is between Satterthwaite and New Zealand Shipping. So how does this work? The parties presented various possibilities as to why there should or should not be a contract between Satterthwaite and New Zealand Shipping. For our purposes, we can really look at three possibilities because these are the possibilities that the Privy Council considered in its judgment. The first possibility is that there is indeed a contract between Satterthwaite and New Zealand Shipping, and it is formed at the same time that the original contract between AM Satterthwaite and Federal Steam Navigation is formed. Now, this possibility is discussed in the judgment, both the Privy Council and the previous Court of Appeal and Court of First Instance stage in New Zealand, and in fact it is pretty easily dismissed by all three courts. And the reason why is that there is no way of showing that New Zealand Shipping provided any consideration at the time of the original contract between Satterthwaite and Federal Steam Navigation. Essentially, at the time when it was agreed that this machine would be sent from Liverpool to New Zealand via the Eurymedon. At that time, New Zealand Shipping hadn't done anything at all. They had perhaps not even been appointed to unload the ship. They had done nothing at all. If you haven't done anything, then obviously you are not capable of having supplied any consideration. So for that reason, this first possibility was dismissed at all levels. Second, the possibility arose that there might be a contract between Satterthwaite and New Zealand Shipping, and that this contract, so this is what we call the third contract, might have come into being at some time after the original contract between Satterthwaite and Federal Steam Navigation was formed. So we accept, following on from the first possibility, that it is not possible that Satterthwaite and New Zealand Shipping had a contract at the same time that the original contract was formed. That's not possible. But what if the original contract is formed and then through some mechanism or some form of action, later on, while this plays out, while this machine is being transported, a contract arises between Satterthwaite and New Zealand Shipping. So this is a very interesting possibility, and in fact that's one that the court probably spent the most time focusing on. The third possibility, which is of course advanced in this case by Satterthwaite, is that there is in fact no contract between Satterthwaite and New Zealand Shipping because of privity. In other words, whatever Satterthwaite agreed with Federal Steam in their original contract, what we called contract number 1, only those two parties, Satterthwaite and Federal Steam, are privy to that. Third parties cannot derive rights from that contract, from that first contract. That, of course, is the doctrine of privity, Tweddell and Atkinson. The majority of the Privy Council agreed with the second possibility. In other words, they held that there was an original contract between Satterthwaite and Federal Steam Navigation, and then at some point subsequent to that, another contract came into being between Satterthwaite and New Zealand Shipping. How would that work? Well, the court offered this explanation. The court held that the original contract between Satterthwaite and Federal Steam contained a unilateral offer. Now, what would that unilateral offer be? Well, essentially, recall that contract, the original contract, had an exclusion clause, and the original contract also mentioned that this exclusion clause should apply to other parties, third parties, contractors and agents, and so on. Now, we could look at that exclusion clause and the extension of it to third parties and treat that as a unilateral offer, which is what the court did, by saying that once those third parties do certain things, they have accepted that unilateral offer, and hence they can make use of that exclusion clause. They fall under it. Now, unilateral offers, of course, are what we know from Carlyle and the Carbolic Smokeball Company, where someone puts out an offer, essentially to the world, and by doing certain things, the offeree accepts and a contract is formed. Now, for this to work in the current circumstances, we need to apply what's called the Lord Reed test from Midland Silicones and Scruttons. Now, technically what would have happened is that AM Satterthwaite and Federal Steam had a contract, the first contract. As part of this contract, Federal Steam was acting as an agent for third parties who may at some point perform certain services in respect of that first contract. And if Federal Steam was acting as an agent and all of the Lord Reed test elements are satisfied, that might then give rise to a new contract between Satterthwaite and New Zealand Shipping. So the Lord Reed test is essentially, I've cut it down here to 4 parts because they're the 4 parts that we should concern ourselves with. There's a 5th part that has to do again with bills of lading, and we'll really leave that to the shipping law. For our purposes, for contract law, what's important is that the contract mentions, that means the first contract between Satterthwaite and Federal Steam Navigation mentions that there may be third parties involved. So essentially, Federal Steam Navigation tells Satterthwaite right at the outset that they may use contractors as part of performing their promises. Okay, fine. Secondly, and that was certainly the case. Secondly, Federal Steam Navigation should or must also have mentioned right at the outset that they may act as an agent for such third parties, which again they did. And thirdly, the third party gave authority to the agent, or gave authority to Federal Steam Navigation to act as its agent. All those 3 were certainly in place. The tricky one, in terms of the majority of the Privy Council, was the consideration part. All of this only works if the third party provides consideration in order to create this new contract, what we called Contract 3. Now, this is a great application of an obiter because the Lord Reed test in Midland Silicones is essentially a hypothetical. Lord Reed said, well, I could imagine in such and such circumstances that there may be a possibility of creating a new contract between one of the original parties and a third party. And in order for that to happen, this and this and this has to happen. But of course, the facts in Midland Silicones didn't allow that to happen. So we are now looking at a situation some years after Midland Silicones where the facts fit the Lord Reed test. So it's an application of the obiter, which of course then creates a ratio. And here's an illustration of how the majority of the Privy Council found that there was in fact good consideration to support a contract between Satterthwaite and New Zealand Shipping. Recall that consideration can be in the form of a detriment suffered by one of the parties. In fact, the Privy Council identified 2 detriments suffered by New Zealand Shipping. First, they had to actually unload the ship. Second, by being in a contractual relation with Satterthwaite, they made themselves susceptible to being sued by Satterthwaite, which is a detriment.